I'm Nikki Jovicic from Lookupstrata and I'm your host for today. With all the rain in New South Wales, are water leaks causing headaches in your strata scheme? We have Adrian Mueller from JS Mueller Co Strata Lawyers here today to guide us through the Owners Corporation's duties regarding water leaks and common property repairs. Can the OC simply afford the issue or drag its feet on repairs? Adrian will address the OC's legal obligations to fix leaks and the consequences of inaction. Adrian will also discuss potential compensation options if the OC fails to fulfil its repair responsibilities, including an explanation of the NCAT process. We welcome today Adrian Mueller from JS Mueller Co Strata Lawyers. Adrian has specialised exclusively in strata law for over 22 years. He's delivered groundbreaking papers to strata lawyers and the strata industry and lectured extensively on strata law topics. He has been published in many mainstream and industry broadcasts and digital and print media publications for his extensive knowledge of strata law. In recognition of his outstanding ability, Adrian has been admitted as a Fellow of the Australian College of Community Association Lawyers, which is the peak body for Australian strata lawyers. So welcome back, Adrian. Thanks again for joining us today. You've been here for a few of our webinars and it's great to have you back with us.
Good morning, Nikki. Good morning to our audience, and thank you for having me again. There has been unprecedented rainfall in New South Wales over the course of the last 2.5 years, and that in turn has led to a lot of water leaking into apartments in strata buildings across the state. And that has resulted in an explosion in litigation in which lot owners are suing their owners' corporations, primarily in the New South Wales Civil and Administrative Tribunal, to seek orders to force their owners' corporations to repair defects in the common property of their buildings that are allowing water to leak into and cause damage to their apartments, and also suing their owners' corporations for compensation for losses apartment owners are suffering as a result of water ingress affecting their apartments. So I'll just share our PowerPoint presentation and have a look at the agenda for our session this morning. We're going to take a deep dive into the duty of an owner's corporation to maintain and repair common property. We'll take a little history lesson when we do that, and we'll explore the nature and content of that duty. What does it actually require an owner's corporation to do, and how quickly does an owner's corporation have to do it? We'll then look at some attempts that have been made to water down the duty of an owner's corporation to maintain and repair common property. We'll look at ways in which an owner's corporation can avoid that duty or defer it. We'll then take a look at what happens when things go a little bit pear-shaped and an owner's corporation doesn't fix common property defects. And we'll look at what remedies apartment owners have in those circumstances. And then we'll move on to some practical issues. We'll look at it from the perspective of apartment owners and consider what those owners need to do to prove their case if they decide to sue their owners' corporations. And we'll then look at defence strategies for owners' corporations who are on the receiving end of a legal claim made by apartment owners. So hopefully there's a little bit in this session for everyone, no matter which side of the fence you sit on. The duty of an owner's corporation to repair common property is one of the fundamental duties of every owner's corporation in this state. It's a duty that has existed since the first generation strata legislation commenced in 1961, and it's a duty that has existed essentially in its current form since July 1974. The duty in New South Wales is currently contained in Section 106 of the Strata Schemes Management Act 2015, and it sets out in very simple language what an owner's corporation's responsibility is in relation to the common property. So an owner's corporation must firstly properly maintain common property. Secondly, keep the common property in a state of good and serviceable repair. And thirdly, where necessary, renew or replace any fixtures or fittings that are comprised in the common property. And that duty applies to every single owners corporation in New South Wales. There is, possibly unsurprisingly, a large body of case law that has developed over the last 50 years relating to the nature and scope of the duty of an owners corporation to maintain and repair common property. And those cases have often involved disputes about whether an owners corporation was required to act and actually do something to fix a defect in the common property, and also a dispute about whether an owners corporation could relieve itself from that duty and decide not to maintain and repair common property or part of it. In almost all of those cases, the dispute was precipitated, pardon the pun, by water ingress affecting one or more lots in a strata building. So let's take a look at some of the earlier cases that involved disputes between apartment owners and their owners corporations about water ingress and what we can learn from those earlier cases. One of the first reported strata cases involved a unit that was owned by Mr. and Mrs. Allen in Sydney. And in that case, Mr. and Mrs. Allen moved into their unit, which they bought from the developer of their building in 1966. And this will ring true with a number of our audience. Within a year of moving into their apartment, they noticed water leaking into the apartment through the external walls. The owners corporation refused to do anything about that problem. So Mr. and Mrs. Allen took them to the Supreme Court, which back then was really the only place they could go. And they sought a declaration from the court that the owners corporation was responsible for carrying out the repairs that were necessary to that external wall to stop water leaking into their apartment. And they were successful. And that case really started off a chain of cases that all had a common theme, namely water leaking into an apartment, resistance by an owners corporation to fixing the problem, and an aggrieved apartment owner who was not prepared to sit back and allow their unit to continue to be damaged by the continual ingress of water. We had to wait another 5 years back in the 1970s for the next relevant case dealing with this issue, the case of Jacqueline. And Jacqueline's case was a really interesting one because what you had there was an apartment tower separate to which were several townhouses. They all form part of the same strata scheme. The owners corporation decided that they would no longer maintain and repair the common property associated with the townhouses. Why? Because the apartment owners who owned units in the tower thought it was unfair that they had to contribute to the upkeep of the townhouses, which were situated well away from the apartment tower. So the owners corporation passed a resolution purporting to relieve itself from the responsibility for maintaining and repairing the townhouse common property and foist that responsibility onto the townhouse owners. That dispute wound up in the Supreme Court. The Jacquelines were the owners of one of the townhouses, and they succeeded in convincing the court that what the owners corporation had done was unlawful and that the owners corporation couldn't simply elect not to maintain and repair the common property, no matter where that common property was situated. We then move on to Fernie's case, which was in 1976. And Fernie's case involved a strata apartment building that contained a number of original construction defects. A number of people in our audience today who have bought into relatively new apartment buildings are no doubt dealing with defects in those buildings attributable to the original construction of the common property. And in this case, surprisingly, these days, there was a dispute about who was responsible for fixing the original defects in the building. And the owners corporation sought guidance from the court as to whether it had the power to make improvements to the common property to fix those original defects. For example, by adding waterproofing or weatherproofing elements to the building that should have been there from day one, but weren't constructed by the original builder. And what the court said in that case was, no, the owner's corporation has to fix any defects in the common property, even if they are original construction defects, because if that was not the case, there would be no one who bore that responsibility. We then move on to 1986. And can I just pause to observe that having to wait 10 years for a strata case to be reported nowadays is unheard of. The modern trend is for there to be a strata case involving disputes about repairs and maintenance published on the New South Wales case law website almost on a weekly basis. That's how things have changed in our society. Anyway, back to 1986. That was a case involving an air conditioning system that serviced only the ground floor of a strata building. And the owners' corporation thought that because that air conditioning system only benefited a minority of owners, they could elect not to replace it or repair it because it had stopped working properly. They were wrong. And the court said, no, even if the majority of owners won't benefit from the repair or replacement of an item of common property, the owner's corporation still has to attend to that maintenance or the replacement of that item. We then move forward to 1993, and 1993 is a seminal moment in strata law because it's the first time an apartment owner succeeds in a claim against an owner's corporation for damages for a breach of the duty to maintain and repair common property. That was Lebrano's case, and that involved water ingress affecting Mr. Lebrano's apartment. The owner's corporation didn't correct the defects that were allowing the water to leak into his apartment, so he took them to the Supreme Court and he won. One of the things that's interesting that came out of that case was that the Supreme Court said that the owner's corporation is responsible for fixing defects in or damage to the common property, even if the owner's corporation didn't cause that damage. And the judge gave an example. He said, well, say, for example, Mr. Lebrano went up onto the roof of the building, took a sledgehammer and smashed the roof to smithereens. Assuming that roof is common property, would the owner's corporation still have to fix the damage he caused to the roof? And the answer is, at least back in 1993, yes, they would. The owner's corporation might have a claim against Mr. Lebrano to recover the cost of fixing the roof, but the owner's corporation still had to fix the roof. And it didn't matter why the roof was damaged and whether the owner's corp caused that damage or not. We then get to 2006, and in 2006 we have the seminal case of Sewa, and the Sewa case involved, again, water leaking into an apartment in a building in Sydney through waterproofing defects on an external terrace. The waterproofing membrane on that terrace was shot and it needed to be repaired or replaced. The owner's corporation refused to do that work. So Sewa applied to the Supreme Court for an injunction to force the owner's corporation to do the necessary repairs to the membrane and to pay damages for the losses that Sewa suffered, and they were successful. And the owner's corporation was ordered to fix the problem and pay compensation to Sewa for the loss in value of the apartment as a result of that water ingress if the ingress wasn't fixed within a certain time frame. A number of very basic principles were laid down in the Sewa case that still hold true to this day, 18 years later. And those basic principles are now on the slide in front of us. They are really important. They are absolutely fundamental. The first is that the duty of an owner's corporation to maintain and repair common property is compulsory, not optional. So an owner's corporation can't elect not to maintain and repair common property, subject to some limited exemptions that I'll talk about later. Next, and this is probably one of the most important fundamental principles, the duty of an owner's corporation to repair common property is absolute. It's not a duty to use reasonable care or to take reasonable steps to repair the common property, but a strict duty to maintain and keep the common property in repair. So, one of the questions I'm often asked in practice by strata committees and strata managers is this. We have a defect in the common property. It's allowing water to leak into an apartment. how long does the owner's corporation have to fix that defect? And my answer is, you have to fix that defect immediately. Now, that sets the bar extremely high, and some would say that's incredibly unrealistic, and we can talk about some other examples that illustrate that point. But the way the courts have interpreted the duty of an owner's corporation to repair the common property, the bar has been set that high. That in effect, the owner's corporation needs to fix it before it's broken, and once it's broken, the owner's corporation has to fix it immediately. The owner's corporation also has to attend to preventative maintenance. So the owner's corporation needs to have a preventative maintenance program in place, in effect, to ensure that the common property is kept in a state of good and serviceable repair. There are some other principles that are laid down that I've already discussed that come out of the cases that we've reviewed briefly. And importantly, the duty to repair common property is owed to each owner in the building. And if that duty is breached, then an owner can sue the owner's corporation for damages to recover any reasonably foreseeable losses the owner suffers as a result of that breach of duty. To emphasise what I just said, in the Sewa case, the judge, a very well-respected judge, said this: as soon as something in the common property is no longer operating effectively or at all, or has fallen into disrepair, there has been a breach of the duty to maintain and repair the common property. So when I'm asked the question, how long do we have to fix it? The answer is, you've got to fix it immediately. That point was illustrated by the West Australian Court of Appeal in a case called Drexel London, which involved a number of claims arising out of the collapse of a timber frame balcony in a strata building in Western Australia. And some of the people who were injured when that balcony collapsed, whilst they were standing on it, sued, among other things, the owner's corporation of the building. And they said that the owner's corporation's duty to repair the common property was strict. The moment that balcony collapsed, the owner's corporation was in breach of duty, and the owner's corporation was liable to compensate them for their losses. Now, in Western Australia, the position is different, and the Court of Appeal disagreed with the interpretation the New South Wales courts had placed on the duty to repair common property. And the court in Western Australia said that what the New South Wales courts have essentially done is put the owner's corporation into the position of an insurer, that immediately something goes wrong in the common property, even if the owner's corporation couldn't possibly know about it, the owner's corporation was on the hook. And the court said that's not the way the duty is meant to be interpreted. So that was the position in Western Australia. It's not the position in New South Wales. It remains to be seen if someone is brave enough to run the argument in New South Wales that the long line of authority that really starts back in 1970 and reaches its high point with the Sewa decision in 2006 is all wrong, and that the judges in New South Wales have interpreted the content of an owner's corporation's duty to repair common property incorrectly, and that the approach taken by the West Australian Court of Appeal is the correct approach. No one's been brave enough to run that argument yet, but I suspect it may well be run in the future. So let's take a look at attempts that have been made to limit the duty to repair common property. There are essentially 4 primary ways that an owner's corporation can relieve itself from its duty to repair common property or defer compliance with its duty. The owner's corporation can avoid its duty to repair a particular item of common property, firstly, if it passes a special resolution at a general meeting to determine that it's inappropriate to maintain, repair or replace that specific item of property. The owner's corporation can only do that if it's satisfied that that decision won't affect safety or detract from the appearance of the common property. So, for example, if there is an old air conditioning system on common property that's broken, it's going to cost $500,000 to replace it, and the owners decide that they don't have sufficient funds to cover that cost, and they're not going to replace the air conditioning unit, they want to leave it be, they can attempt to relieve the owner's corporation from its duty to repair or replace that air conditioning unit by passing a special resolution to determine that it is inappropriate to replace that air conditioning unit. Secondly, an owner's corporation can make what's called a common property rights bylaw to give one or more owners special rights over a particular part of the common property, such as the exclusive use of that common property, and impose on them through that bylaw the responsibility for the maintenance and upkeep of that common property. That type of a bylaw requires the written consent of the owners who will have that responsibility. But once that bylaw is made, it relieves the owner's corporation from its duty to repair the common property that's covered by that bylaw. And thirdly, the owner's corporation can make a bylaw to adopt what's known in New South Wales as a common property memorandum. And that's a document that allocates the responsibility for the maintenance and repair of a whole heap of individual items of common property between the owner's corporation on the one hand and individual owners on the other hand. So to take an example, getting back to air conditioners, under the common property memorandum, individual owners are responsible for the maintenance and repair of air conditioning systems that are situated on the common property that solely service their lots and no other lots. And the common property memorandum can be adopted by an owner's corporation without needing to get the written consent of the owners. It just requires a special resolution. How can the owner's corporation delay or defer its duty to repair common property? Well, this is something new that was introduced in New South Wales when the Strata Schemes Management Act was rewritten and commenced in November 2016. Where a person damages the common property, the owner's corporation can defer its obligation to repair that damage if it takes action against the person who caused the damage. So, as I said earlier, some of these ways in which an owner's corporation can relieve itself or defer the obligation to comply with its duty to repair are inspired by some of the cases that we just looked at. And here this harks back to the example the judge gave in Librano's case. What happens if a unit owner deliberately damages common property? Does the owner's corporation still need to fix it? And the answer is no, if the owner's corporation takes action against that owner. Now, arguably, this also applies to original construction defects. So if an owner's corporation is suing the builder and developer of its building for damages as a result of construction defects or for orders to require the builder and developer to repair or correct those defects, then again, the owner's corporation can put on hold its obligation to repair those defects. It's not clear what action is required, whether that means legal action or something less, and it only applies if there's no safety risk. So if there is still a safety risk created by some damage to or defect in the common property, the owner's corporation still has to act and fix the problem. Let's take a look at what remedies are available to apartment owners when an owner's corporation doesn't maintain and repair common property. There are three primary remedies. The first is an application for an order known as an injunction to force the owner's corporation to repair the common property. The second remedy is damages for losses. And the third remedy is the appointment of an administrator or compulsory strata manager to manage the affairs of the owner's corporation and to organise the repairs and maintenance that need to be done that the owner's corporation has failed or refused to do. There's a lot of law about those remedies that has developed, particularly in the last 15 years. If we take a look at some of that law, it makes clear the following principles. NCAT can make an order to force an owner's corporation to fix defects in the common property that are allowing water to leak into an apartment. But NCAT can only do that where the work order it makes is specific and sets out typically a very detailed scope of works that leaves no room for doubt precisely what it is the owner's corporation needs to do. That normally requires expert evidence and reports and the like. A recent case that was only handed down last week in New South Wales indicates that NCAT can still make orders to require an owner's corporation to investigate what needs to be done to fix defects in the common property. And NCAT also has the power, somewhat surprisingly, some would say, to order an owner's corporation to fix consequential damage caused to an apartment by a common property defect. So to take a very simple example, if water leaks through a common property wall and damages a carpet inside an apartment beyond repair, if we assume the carpet forms part of the lot, then NCAT can order the owner's corporation to replace that carpet. Turning now to compensation. Quite often when water leaks into an apartment, the apartment owner will suffer financial loss. There are numerous cases in which NCAT and the courts have awarded apartment owners damages to cover that loss. And this slide provides some examples of the types of loss that unit owners can recover. So if you're a landlord, you have an investment apartment, it's inundated by water, the water causes mold, the apartment becomes uninhabitable and your tenant has to move out and you can't rent the apartment for some time, then you can claim rental loss from the owner's corporation. If you own and live in an apartment and it becomes uninhabitable because of water ingress, you have to move out and rent premises elsewhere, you can recover the alternate accommodation expenses you incur. If water comes into your apartment through a common property defect and that causes damage to the contents of your apartment, your lovely coffee table gets inundated by water, you have to replace it, you have to replace your carpet or rugs or the like, then once again, you can recover the cost of having to repair or replace those contents. You can, in some circumstances, also recover legal costs you incur, even before you start litigation, trying to compel the owner's corporation to comply with its duty to repair common property. And if you have to hire experts to help you prove that there is a defect in the common property that needs to be fixed, you can also recover their costs from the owner's corporation. And probably the most drastic remedy that's available to an apartment owner is an application to NCAT to have a compulsory strata manager appointed, and NCAT can appoint a compulsory strata manager who acts like an administrator who will have the power to do either the repairs that are necessary or the power to exercise all of the owner's corporation's functions. Let's get to some practical things. Firstly, looking at things from the perspective of apartment owners that want to make a claim against their owner's corporation in NCAT or a court to seek orders for repairs or compensation. What do you need to prove to win your case? Well, the starting point is you need to prove that you're an owner. Now that might seem obvious, but there is a nuance here. I've particularly recently seen a number of cases in which people who have sold their apartments have then brought claims against owners' corporations after settlement of the sale, claiming, for example, the loss in value of the apartment. So the example might be, I could have sold my apartment for $1 million, had water not leaked into it through a common property defect, but because the owner's corporation didn't fix the defect, I could only fetch $500,000 for my apartment. So I'm going to sue the owner's corporation for my loss, $500,000. Now, you can do that, but arguably you can't do that in NCAT because NCAT only has the power to entertain claims by current owners, which means you'd likely need to go to a civil court to run that claim, which generally is a bit more complicated, time-consuming and expensive. Secondly, you have to identify the defect in the common property that the owner's corporation hasn't fixed. So it's not enough for you as an apartment owner to say, water leaks into my apartment, ergo the owner's corporation has breached its duty. You have to actually identify what component of the common property is defective to prove that there was a breach of the duty of the owner's corporation to repair it. If you want NCAT to order the owner's corporation to repair that defect, you're going to need to put forward a scope of works for that repair. You generally can't simply ask NCAT to order the owner's corporation to, quote unquote, fix the problem. That's not specific enough. So you need to spend the money getting an expert to write a report for you to indicate what needs to be done to fix the problem. If you're going to be claiming compensation, then the touchstone is that you need to prove that your loss was, number one, caused as a result of the breach of the owner's corporation's duty, and number two, that your loss was reasonably foreseeable. You have to prove your loss. So if you're claiming, for example, the cost to repair damage to your apartment or to clean your apartment, you have to produce quotes and invoices to prove that you incurred that expense or that you will incur the expense. If you have lost a tenant and you're claiming rental loss, you have to prove what rent you could have fetched during the period that your unit was vacant. So you have to put into evidence your tenancy agreement, rent ledger, receipts for rental payments from your former tenant. You might even need to get a report from a real estate valuer proving the current market rental value of your apartment. You also need to make your claim, in New South Wales at least, within 2 years of first becoming aware of your loss. This is really important. This is something new that was introduced into the Strata legislation in November of 2016. It's had a lot of recent judicial attention. And what it means is this, to illustrate the point by way of an example. If water leaks into my unit and makes it uninhabitable for my tenant, then the moment I realise my tenant is not going to pay me rent, the clock starts to run. What that means is I have to sue my owner's corporation within 2 years of me first becoming aware of me suffering rental loss. It is not good enough for me to write to my strata manager or owner's corporation and say, I'm putting you on notice that I'm going to make a claim against you. No, you actually have to start the legal action within that 2-year period. And if you don't, then you have run out of time and you can't bring a claim for compensation for those losses, relying on a breach of the duty to repair common property. You might still have a right to bring the claim in negligence, but that's a much more difficult claim to succeed in. If we hop over to the other side of the fence, if I'm acting for an owner's corporation, what are some defence strategies that they can employ? Well, the bad news is that the duty to repair is a strict duty, so it's quite often very hard to dispute that you're in breach of that duty, however unfair that might seem. Even if you didn't know about the problem with the common property, the fact is that once that problem exists, you as an owner's corporation are in breach of duty. So these types of claims can be difficult for an owner's corporation to defend. And so as I say in the slide, sometimes you need to see the writing on the wall and realise that an acceptable surrender is the preferred and better outcome. But all is not lost. Sometimes you can fasten onto technical flaws in a claim made by owners. Just to digress briefly, most claims in NCAT by apartment owners involve self-represented litigants who run these cases themselves. So most apartment owners don't hire a lawyer with expertise in this field to run the cases for them. They do it themselves. And that means that a number of the owners are unsuccessful when they run these claims. For a number of typically technical reasons, but not always. Firstly, I often see the form of orders that's sought by self-represented apartment owners is defective, that NCAT just can't make orders in the form written in the application lodged by the owner. Or secondly, the application lodged by the owner discloses no legal basis for NCAT to make the orders. The owner doesn't explain what cause of action he or she is relying on. And sometimes, and this is probably the most common problem I see with apartment owners running their own claims, they don't provide enough evidence to prove their case. So for example, the evidence might be this: water leaks through my ceiling. It's caused water staining and paint to flake on the ceiling of my apartment, and that's it. There's no evidence to prove what the cause of that water leak is. There's no evidence to prove the leak is coming from the roof of the building or perhaps through a wall, or could it be caused by the tenant in the unit upstairs leaving the tap on in their bath and the bathroom flooding and the water coming through the slab. So quite often owners are unsuccessful because they just don't prove their case. Sometimes the work an apartment owner wants the owner's corporation to do goes too far. So there is some good law which says that all NCAT can do is order the owner's corporation to do the minimum work necessary to discharge the owner's corporation's duty to repair the common property. So there might be 5 different ways in which a defective item of common property can be repaired. And the one NCAT is meant to choose is the one that results in the owner's corporation doing the minimum necessary to put that common property into good repair, not the Rolls-Royce repair. So there is some scope for an owner's corporation to argue that the apartment owner seeks work orders that just go too far. Quite often the apartment owner won't rely on any expert evidence. or expert evidence that's credible. So they might just produce a quote from a contractor whose credentials aren't known, saying, here's a quote for $20,000 to fix your water leak. And quite often NCAT won't accept that evidence because the evidence has limited probative value. And the apartment owner really needs to get an expert to write a litigation compliant report to prove their case. Importantly, the loss that's claimed by the owner has to be caused by the breach of duty. And there was a case that I referred to earlier that was handed down last week, where an owner's corporation argued that the loss claimed by the owner was not caused by its breach of duty, but rather by the owner's unreasonable conduct. So to cite an example, if I'm an investor owner, water leaks into my apartment as a result of which my tenant moves out, and I'm suffering rental loss, and the owner's corporation comes knocking on my door and says, let us in, we want to fix the problem, and I say, no, go away, I'm not letting you in, then there's a good argument that the rental loss that I suffer, or at least part of it, is not caused by the breach of duty, but it's caused by my own unreasonable conduct, or in legal parlance, my failure to mitigate my loss. So that's an example of where an owner's corporation has some scope to argue that it's not culpable for all of the financial loss that an owner claims. So Nikki, that takes us to the end of the presentation. I hope that was very useful for our audience and that a lot of questions the audience have already been answered, but I'm now happy to take some more specific questions.
Wonderful. Thanks so much, Adrian. That was great. For over 2 years, I've been trying to get the OC to carry out some repairs and maintenance to the common property. There is a reluctance to get any of it done. I get different excuses as to why the OC can't or won't arrange the required repairs. Can the OC elect to not repair or maintain the common property? And if not, what is the reasonable time frame for the OC to carry out its duty?
In general, the owner's corporation can't elect not to maintain and repair the common property. The owner's corporation's duty to repair the common property is compulsory, not optional. So the owner's corporation has to fix the problem unless one of those 4 ways in which the owner's corporation can avoid having to fix the common property or can defer its obligation to do so applies. And usually none of those 4 ways will be relevant. And the answer to the question is, by and large, the owner's corporation has to fix it.
What can we do when an NCAT order includes an unachievable timeline to complete works that require a structural engineer's scope, the issuance of tender documents, the selection of a tenderer, and the completion of the works?
So if the time frame is unrealistic, then really what the owner's corporation should be doing is trying to go back to NCAT to have that time frame extended. And that should initially be done by way of an attempt to reach an agreement with the apartment owner on an extension of time that's appropriate, and an explanation should be given to the owner and, if necessary, NCAT as to why the work can't be completed within the timeframe specified by NCAT.
The OC has a duty to maintain common property. However, with such torrential rain, issues arise. Engaging an engineer and going to tender with qualified builders all takes time. Although we have a reasonable amount in the Capital Works Fund, a special levy is required. Costs of works regulated under the Design Practitioners Act can be excessive. Where do owners stand when they're trying to do the right thing, but getting funds together takes time? What options are available, and how do pensioners handle this so they don't lose their homes?
This is a question I get asked often. It appeals to the practical reality that an owner's corporation can't fix common property defects immediately. It takes time to raise the funds necessary to do so, put works out to tender, let a contract, and get the work done. Unfortunately, none of that matters in this sense, that as I said during our seminar, the courts have interpreted the duty of an owner's corporation to repair common property as a strict one. So it gets back to what I said earlier. The owner's corporation has to fix that problem in the common property immediately. I fully accept that is unrealistic in many cases, but that is the way in which the courts have interpreted the strict nature of the owner's corporation's duty. So for example, if an owner's corporation winds up in NCAT and says, look, we had all the best intentions to fix this problem, but it just took us 6 months to get our expert in to write a scope, to put the scope out to tender, to then get the tender analysis, to then raise the special levy or take out a strata loan, to then let the owners pay that levy. and then finally let the contract and get the contractor on site. NCAT is going to say, that's wonderful, but unfortunately the law is not on your side. You needed to fix that problem immediately and you didn't. Therefore, you were in breach of your duty to repair the common property.
Can the strata manager be held liable for damages if the Owners Corporation or strata committee refuse to carry out repairs and maintenance?
So the answer to that question is possibly yes. And there are really two primary considerations, Nikki. The first is, what functions of the Owners Corporation have been delegated to the strata manager? And in particular, has the strata manager been delegated the function to organise maintenance and repairs to the common property? And if the answer is no, then no, the strata manager can't be held liable because that's not his or her responsibility. And if the answer is yes, then possibly the strata manager might be liable if the strata manager was negligent. And the second consideration is, what limitations on the liability of the strata manager are contained in his or her agency agreement? Most standard form agency agreements, particularly the ones published by Strata Community Australia, contain very broad limitations on the strata manager's liability. That would make it very difficult for an owners corporation, for example, to say, well, you're our strata manager, you should be looking after repairs and maintenance, this is all your fault, and we want you to indemnify us for any money we're ordered to pay this poor apartment owner whose apartment was wrecked by water ingress. Those limitations of liability obviously aren't binding on apartment owners because they don't have a contract with the strata manager, but they will have an effect on what duty of care, if any, the strata manager owes the individual apartment owner who suffered the loss.
If the owners have passed a bylaw saying owners are responsible for common property, i.e. doors and windows for repairs and maintenance, who's responsible if the building is a new build and an expert report said the sliding doors are a defect and that is why the water flooded through the unit?
So if those doors are common property, then the owners corporation is responsible for fixing the problem, subject to two possible exemptions. One, if the owners corporation has taken action against the builder or developer to try and have those defects fixed, then the owners corporation arguably can defer its responsibility to fix that problem. Secondly, if there is a valid bylaw in place that transfers from the owners corporation to the individual owner the responsibility for the repair of that door, then the owner bears that responsibility. But if we just pause there for a moment, you'll note that I said if the bylaw is valid. A bylaw that says nothing more than the lot owner is responsible for the maintenance and repair of their balcony door would not be a valid and enforceable bylaw, because the bylaw would be directly inconsistent with the section in the Strata Schemes Management Act that imposes on the owners corporation the duty to repair that door, and a bylaw can't be inconsistent with the Act. So in order for a bylaw to be effective, it would need to be what's called a common property rights bylaw that confers on that owner the exclusive use of that door and also imposes on the owner the responsibility for its maintenance and repair. And provided that type of bylaw is validly made, typically with the written consent of that owner, then it would be the owner's responsibility to fix the problem.
If a building is 97 years old and the unit affected by damp was formerly a garage and a basement level, is there still a requirement for the owners corporation to fix the waterproofing? What happens if it's not economical to do so?
So that's a great question, and one that I've been asked in the course of my practice. There is an available argument to an owners corporation that a garage does not have to be watertight, and that it is still permissible for some water to leak into a garage area under the National Construction Code. There were one or two old cases that dealt with that issue in which one of the predecessors to NCAT was persuaded that the owners corporation is not responsible for making a garage completely watertight, and if there is some water leaking into that garage, that's still permissible and does not mean that the owners corporation is in breach of its duty to maintain and repair the common property surrounding that garage. That point is a bit of a grey area. There aren't any recent cases that I'm aware of that deal with it, but certainly there's some scope to argue that the owners corporation has some wriggle room. The fact that the building might be 97 years old doesn't really matter. in the sense that the owner's corporation's duty is to still maintain and repair the common property. And if the building has a defect in the common property, then the owner's corporation would still need to fix it, even though the building might be 100 years old.
Can lot owners fix the problem themselves first using licensed contractors and then claim the money back from the OC?
The answer to that question is no, without the consent of the owner's corporation or an order from NCAT permitting the owner to do the work. So there is a case that was decided by the Supreme Court about 15 years ago that dealt with that very issue, a case called Leslie Swan. And in that case, the apartment owner, Ms. Leslie Swan, claimed, among other things, that the floor tiles on her balcony were defective, that they were common property, and she wanted the owner's corporation to replace them. The owner's corporation refused to do so. So Ms. Leslie Swan took it upon herself to replace those tiles and then sued the owner's corporation to recover the cost of doing so. She was ultimately unsuccessful when the matter got to the Supreme Court by way of an appeal from the local court. And what the judge in the Supreme Court said is this: the legislation puts on the owner's corporation the responsibility to maintain and repair common property. Individual owners don't have that right to do so. They shouldn't be encouraged to do so without the consent of the owner's corporation by doing the work and then coming to NCAT or the court and putting their hand out asking for reimbursement. So owners who take the law or matters into their own hands and do their own maintenance and repairs to the common property without the consent of the owner's corporation shouldn't expect to be reimbursed for that cost.
Can a bylaw be made to pass responsibility for bathroom tiles and waterproofing to the owners?
The answer is yes, provided you get the written consent of those owners. So you have to make a bylaw that gives the owners the exclusive use of their bathroom waterproofing and tiles and imposes on them the responsibility for the maintenance and upkeep of those items of property. And the legislation requires you to do three things to validly make that bylaw: pass a special resolution at a general meeting, get the written consent of all of the owners, if the bylaw will apply to all of them, and register the bylaw. If you don't get the written consent of all of the owners, then there is a case which says that you do not have the power as an owner's corporation to pass that bylaw. In practice, what often happens is the owner's corporation will still pass and register the bylaw, even though it won't have the written consent of all owners. That action is unlawful, but nevertheless it happens a lot. And there is a provision in the Strata legislation which says that if no one challenges the validity of that bylaw within 2 years after it being made, there is a conclusive presumption that the owner's corporation did everything it needed to do to validly make that bylaw, including getting the written consent of every owner to create that bylaw. So if, say, 5 years after the bylaw is made, there's a dispute about who has to replace a bathroom membrane, and an owner comes along and says, hang on, I never gave my written consent to this bylaw being created. The bylaw's not valid. The owner's corporation has to fix my membrane. NCAT or the court will say, too late, the bylaw is conclusively presumed to be valid on the basis that everyone gave their written consent, even if that didn't actually happen. And there is a case in the Supreme Court where the judge held as much. So don't sleep on your rights.
Is that generally known, do you think, Adrian, or is that a bit of a secret in the industry? Or
it probably is a little bit of a secret in the sense that a number of owners' corporations or strata managers just proceed and drive through that bylaw without the written consent of all necessary owners. And there are some people that sit there crossing their fingers and toes for 2 years, hoping that no one challenges it, and if they get away with it, so be it. They get away with it a lot. But if you have aggrieved owners in the building who are astute enough to know their rights or get proper legal advice, then it's not that difficult to get those bylaws overturned.
That comes back to that check the detail, take notice of what's going on in the building.
Knowledge is power.
Definitely. Okay, thank you. And what is the obligation of the owner to notify the owner's corporation of an issue in terms of timeliness? Is there anything that says the owner's corporation has the right to inspect at time of incident, or can an owner make a claim retrospectively?
So there's really nothing, no obligation imposed on an owner to notify an owner's corporation about a defect. There are some owners' corporations who, bearing that in mind, have introduced bylaws that do place an obligation on owners to notify an owner's corporation of any defects in the common property they become aware of as soon as possible. That bylaw is a very good idea. I would recommend it to any owner's corporation that has an issue with common property defects. But ultimately, if an owner sues an owner's corporation and says there was a defect in the common property and you didn't fix it and I now want you to fix it, it's very difficult for the owner's corporation to say, hang on, you knew about this but didn't tell us, therefore we're not responsible for fixing it. The argument that might be available to an owner's corporation is that the owner didn't mitigate his or her loss by simply notifying the owner's corporation about the problem when the owner became aware of it. And the owner's corp might argue that had that been done, the problem would have been fixed much earlier. And that could have a bearing on the amount of compensation the owner's corporation might be liable to pay the owner.
Can there be legal action towards one owner who is refusing to pay for a special levy to fix a leaking balcony? The level has been approved by the committee members.
The answer is yes. So the legislation in New South Wales says that if an owner doesn't pay a levy within 1 month of it falling due, the owner's corporation is entitled to take legal action against the owner to recover the amount of the levy, plus interest, plus debt recovery costs. There is a requirement in New South Wales, at least, for the owner's corporation to give the owner a written notice warning that legal action will be taken within 21 days of the date of that letter if the levy is not paid. But once that's done, the owner's corporation can go for their life and chase the owner in court or NCAT to recover the levy.
Since I bought my apartment in Sydney, we've had rainwater entering the unit from the common property. I've arranged expert advice and quotes to rectify the problems consistent with the relevant legislations, Designers and Builders Practitioner Act. At the recent AGM, our owners corporation made it clear they have no intention of spending any more than the bare minimum. The focus of our Strata committee seems to be on finding a cheap fix. If we pursue action through NCAT and the OC is ordered to address leaks from common property, how can owners ensure the committee arranges long-term certified and compliant repairs rather than cheap temporary fixes?
Great question, one that often arises in practice. Is a band-aid solution to the problem acceptable? So the touchstone is this: the owner's corporation needs to do the minimum necessary to put the common property into a state of good and serviceable repair. That's all. Reasonable minds might differ about what work needs to be done to achieve that end. If you as an apartment owner think that the owner's corporation is proposing a band-aid solution that is not going to fix the problem, and you can't persuade enough owners in your building to see things your way, then your remedy is to go to NCAT with the support of a report from your expert and persuade NCAT that your expert's scope is the appropriate scope to achieve the minimum necessary in order for the owner's corporation to fulfil its duty to repair the common property, and that the band-aid solution the owner's corporation is proposing is simply not adequate to achieve that minimum standard.
We thank you. Is there anything you'd like to finish the session with? Some final thoughts on this topic?
Nikki, I think what surprises me in practice is that for a lot of buildings, the penny still hasn't dropped. I went to some great lengths during the seminar to explain how strict the duty of the owner's corporation is to repair the common property, but there are still a number of strata committees out there that don't understand the true legal position, or if they do, they don't want to accept it because they think that the bar has been set too high. And whilst I might personally have sympathy for those committees, and I agree, as I've alluded to earlier, that the practical reality is that it's extremely difficult, if not impossible, for an owner's corporation to fix a problem in the common property immediately. The standard has been set by the courts. Who are we to argue with the way in which the courts have interpreted the law? Our role is to abide by the law. Really, the message that needs to get through to some strata committees is that's the law, like it or not. You have to do your best to comply with it. And if you don't, then you will suffer the consequences. So sometimes you just have to suck it up. And unfortunately, that's just the way it is.
Well, thank you for presenting us with those thoughts, Adrian. Great way to finish the session. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.